case briefs, and so much more. LSData's got what you're looking for.
In a riveting Texas appeals court case from 1988, Andrle v. Andrle, a divisive issue emerged over the division of disability insurance benefits after a divorce. The estranged couple found themselves at odds over what constituted community property, a debate with implications that would travel beyond their private lives and into the courts. During their marriage, the couple had invested in a private disability insurance policy using their joint funds. Unfortunately, the husband succumbed to a disability which spurred a lawsuit against their insurance company. The outcome of that lawsuit was a significant lump sum settlement and ongoing disability payments awarded to the husband. The contentious point lay in whether or not the ex-wife was entitled to any portion of these insurance benefits. The husband, who was now unable to work, staunchly argued that the disability payments were purely his personal property. His perspective drew from the Rollator v. Rollator case, highlighting that the benefits were replacing his personal income. However, a different interpretation emerged which ultimately was victorious in the courtroom. The court decided that the disability insurance policy, despite its subsequent scheduling, was community property since its premiums were paid with communal funds during the marriage. Citing the precedent-setting Matthews case, which chalked disability compensation as a property right, the court rejected the husband's argument. The inception of title doctrine insisted the status of any property is established at the point of acquisition. Consequently, no change occurred by the divorce. Thus, despite the husband's appeal, the court affirmed its decision, deeming the disability benefits as community property shared between the divorced couple.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.